Thank you very much for having me here. And Kendra, we are so grateful to you for fighting this cause. If it wasn't for you, we would not be in front of the Supreme Court right now. Are you guys proud of your mom? Let's give her another round of applause. Kendra and I met 4 years ago in a coffee shop in Montana. And it was there that she agreed to be the lead plaintiff in this lawsuit. She had no idea that she was about to become the face of the most important education case in 20 years. I had an idea, though. This case is often talked about in terms of religious liberty, but at its core, it's about parents' right to choose the best education for their child, whether that education is religious or secular. The public schools work fine for most kids, but too many are falling behind or just not reaching their potential. Maybe that's because they go to a failing school that's just not meeting basic academic benchmarks, or maybe they go to a perfectly fine school, but they're being bullied and they're afraid to show up every day. Or maybe they're just not being challenged. These kids should have a choice, and that choice shouldn't depend on how much money their parents have in their bank account. That's what school choice is all about. And it's been very successful. It's been around for 30 years, and there's currently 55 programs in 29 states, plus the District of Columbia. And parents have over a 90% satisfaction rate with these programs. So why don't we see more of them? Why do they only exist in 29 states? Why are they so controversial? What do you guys think? There's two big reasons. Teachers' unions. So yes, there is the perception out there that these programs take money away from the public schools. That's not true, and the studies show that's not true. But we could talk about that later. What's the other big reason we don't see more of these programs? Separation of church and state issues. People think that if the government is making it easier for parents to go to private school, and some of those schools are religious, then that's unconstitutional. And that brings us to the Montana case. So as Kendra said, this case all started when the Montana legislature did what most of their states are already doing, and that's pass this school choice program. But it was challenged. It went up to the Montana Supreme Court, and the court did two things. It said first that it would be unconstitutional to include any religious options in any student aid program, including this one. And then it did something that surprised everybody. It struck the entire program down for both kids going to religious schools and non-religious schools. And the court did that because they said that was the only way to ensure that not even a dime of money wound up going to a family at a religious school. So let's talk about the legal issues. Is it unconstitutional to have religious options in these programs? Does that violate separation of church and state? Well, no. And that's not my opinion. That's the opinion of the U.S. Supreme Court. In 2002, Cleveland passed a program very similar to this one. The ACLU and taxpayers challenged the program and said it would violate the Federal Establishment Clause to have religious options in these programs. So the court looked at the case and they analyzed it. They analyzed it under something called the Lemon Test. Who here has heard of that? A few of you. Okay, so the Lemon Test pretty much asks, what is the purpose of the law and what's the effect of the law? If the primary purpose or primary effect is to advance religion, then it's unconstitutional under the Establishment Clause. But they said here, school choice passes this test. The purpose is secular. It's just to help kids get a better education. And the effect was primarily secular as well. And they found that to be true even though 96% of the kids were using the scholarships to go to religious schools. Why do you think they still found that the program did not advance religion? Anybody know?
Freedom of choice.
That's exactly right. Freedom of choice, because it wasn't the government deciding where to put these kids and what school they should go to. It was the parents. So the government wasn't advancing religion at all. They were just giving parents a choice. So if the US Supreme Court has already said these programs are constitutional, why are we here today? Why did the Montana Supreme Court come out the other way? You know, Jamie. Yes, Blaine Amendments, because this case, the Zelman case, was looking at the Federal Establishment Clause. But states have their own state constitutions, and 37 or 38 of them have these provisions called Blaine Amendments that establish stricter barriers between church and state. So this is Montana's Blaine Amendment. Pretty much it says the government shall not aid directly or indirectly religious schools. I mean, school choice is aiding families, not schools, but let's put that aside. Let's also put aside the fact that even though this seems innocuous on its face, it actually was enacted in the 1800s to discriminate against Catholics, as Jamie told you. We'll put that aside too. The question before the US Supreme Court is if applying this provision to a school choice program violates the Free Exercise Clause. What are we looking at here? Any doctors in the audience?
It's a knee.
It's a knee joint. We've got two bones, and they're held together by a bunch of tissue in the middle, because otherwise the bones are going to be mashing up against each other. That's the play in the joints. Believe it or not, this is how the US Supreme Court looks at religion cases. On one hand, you have the protection of religious liberty, the Free Exercise Clause. And on the other hand, you have the Establishment Clause and separation of church and state. The government doesn't want to trample on people's religious liberty, but they also don't want to go so far that they're advancing religion or endorsing religion. But not every government decision about religion is prohibited or required by these constitutional clauses. There's play in the joints. There's room for the discretion. There's leeway. So what the Supreme Court is doing in this case, the Espinoza case, is deciding whether excluding religious options violates the Free Exercise Clause or if it falls within the state's discretion in the play of the joints. That is the core issue in this case. So we know that states have the choice to have school choice programs that include religious options, but if they have one of these programs, do they have to include religious options? So there's two cases the Supreme Court is going to be looking at to help them answer this very complicated question. Two cases. One of them came out very recently. Anyone know what the cases are? I'm hearing mumbling going on. The playground case, the Trinity Lutheran case, and I'll explain what that is. And what's the other case? This one goes back to 2004. It's actually notorious. You gotta know, Jamie. Okay, I'll stop calling on you. Okay, so we've got Locke v. Davey in 2004. So that case was don't read the slide yet. That case was kind of similar to this one. What happened was Washington State enacted a college scholarship program. Sound familiar to some people? I see nodding. They enacted a college scholarship program, and they said, hey, if you have really good grades, we're going to give you a scholarship, and you could use that scholarship to go to whatever school you want, whether it's religious or non-religious, it doesn't matter. You can take whatever classes you want. There's only one thing you can't do with this scholarship, and that's major in devotional theology. And people majoring in devotional theology are studying to become priests or ministers. They're studying to lead a congregation. And Washington State said, we're just not comfortable with that, so we're going to have this small exclusion. So Joshua Davey, who wanted to become a minister, and he got one of these scholarships, said, hey, I want to major in devotional theology. You're violating my free exercise rights by saying that I can't. And it went all the way up to the US Supreme Court. And the court said, no, actually, that's okay. That does not violate free exercise clause. But they said there was 4 reasons for that being true. 1, this was a very narrow religious exclusion. 2, it didn't show hostility toward religion because religion was very much included in the program. Joshua Davey could go to a religious school. He could even take as many devotional theology classes as he wanted. He just couldn't major in it. 3, for the same reasons, he wasn't forced to choose between his religious beliefs and accepting the scholarship. And finally, it was The reason the state had this exclusion was because our country has a long history going back to the founding and even before our country was founded with the government funding ministers and clergy. And that was one of the reasons that we had to fight for religious freedom in this country, because the government was establishing churches and the state just was not comfortable funding his scholarship here. And the Supreme Court said, you know what, that's okay, we get it. But then another case came down just 2 years ago, the church playground case, as somebody said. This was the Trinity Lutheran case. And what happened here is that Missouri set up a grant program for institutions that happen to have a playground. A lot of playgrounds have gravel on them, and if little kids fall, they scrape their knees. So Missouri said, you could apply and we'll give you soft tire scraps that you could use instead. It's softer, kids can fall all they want. So there were a bunch of people applied, and one of them was a church preschool and daycare program. And initially they got the grant along with 39 other people. But then Missouri looked a little closer and said, oh wait, hold on, you're a church. We can't give this to you under our Blaine Amendment. So the church sued, it went all the way up to the Supreme Court, and the court said, you know what, this does violate free exercise, because the only reason you're not giving them this grant is because they're a church. You're discriminating against them solely on the basis of their religious status. Now, in that opinion, the court also set forth two other fundamental principles. They said government can't discriminate against religious status, they also can't discriminate against religious beliefs, and they can't discriminate against religiously based conduct. So now, in our case, the court is going to be deciding, is this more like Locke v. Davie, or is this more like Trinity Lutheran? So
Could you tell us how the court voted on that case?
I believe that was 7-2, and Jamie's nodding, so I'm correct. And the court, there were some concurrences. The court split a bit, but everybody agreed this was discriminating. The seven justices agreed this was discriminating against religious status.
And the two that dissented?
Was Ginsburg and Sotomayor. So if you guys were the lawyer in this case, and you're arguing in front of the Supreme Court, how are you going to say this is more like Trinity Lutheran than Locke v. Davie? Which case is it more like? Trinity Lutheran. Why?
Because the only reason they're discriminating is for religion, they're punishing.
That's right. That's right. If this case is triggering all these principles. It's excluding religious schools from participating in this program solely based on their religious status. It's discriminating against families based on their religiously motivated conduct. And unlike in Locke v. Davie, this is not a narrow exception that otherwise includes religion in the benefits. This is a wholesale exclusion of any religious educationist program. There's no room for religion here. It's a total exclusion, and it does show hostility toward religion for that reason. Does anybody disagree? Anyone have further comments? Let's take a vote, okay? Who thinks the Supreme Court is going to rule for us in this case? Raise your hand. That's a lot of people. I agree. We have a very high chance for success in this case. I would put it at 90%. I think we're going to have at least 5 to 4 vote in our favor, if not more. And when we win this case, it's going to be a huge victory for families across the country and for Kendra Espinoza. This case has the potential to allow school choice programs for hundreds of thousands of kids, if not millions of children. It's a big deal, and we would not be here today if not for Kendra. So thank you very much.